I should begin by acknowledging that I am speaking to you from the stolen lands of the Coquitlam and Catesy First Nation in what is also known as suburban Vancouver, Canada. I'm delighted to be here. Thank you so much, Camilla and Elsa, for inviting me to join this conversation. I must admit, I did miss the first 3 or 4 papers this morning because, frankly, I was asleep. I'm just now waking up with my cup of tea, but I've very much enjoyed the conversation so far. So because I'm joining late, I may cover ground that has already been covered. If I do so, my sincere apologies. I just ask you to pretend that this is all new and revelatory, and we'll just proceed on that basis. So what Elsa asked me to do was sort of make some more general comments. I think just before the break, she said I might join all the threads together or something, which is not clearly going to happen because I think that has to happen collectively. But what I do want to do is just make some sort of more general, quick comments about access to land and questions of justice and freedom and human flourishing. And I want to focus in particular on property and property rules, particularly private property rules, because they play a crucial role in, of course, configuring access to land. And rights of way are a conditional use that people have in relation to the underlying private property interests that are held in land. But I wanted to begin with the image you're seeing on your screen. I don't know if people have seen this. This is a lovely graphic essay by a cartoonist and journalist called Sam Woolman, who's based in Melbourne, Australia. It's called So Below, and it's freely available. Just go sobelow.org on, and you can find it on your computer. And what So Below is described as is basically a critique of the colonial and capitalist landed property system, exploring what Sam calls territorialism and dominion, and it powerfully critiques the notion of private property and the commodification of land, while also directing us to its powerful geographical manifestations in borders, zones, and spaces of exclusion. The comic or graphic essay begins with this, I think, really lovely point. Every single one of us has a body. We take up space, and so we need some room. Inside of this fact, there seems to dwell a quiet but desperate kind of mania. And this goes back a long way. So we take up space. We all need some room. We are embodied beings who occupy and depend upon space. To have access to some room is to have some freedom. The liberty to perform an action, put another way, requires the availability of a space in which one is free to perform that action. A lawyer called Jeremy Waldron, in an essay maybe 30 years ago on homelessness, made a similar argument, although less graphically visual. Everything that is done, he says, has to be done somewhere. No one is free to perform an action unless there is somewhere he or she or they are free to perform it. We're not free, Waldron and Woolman remind us, unless we have access to a space. Consequently, there is no freedom if space is unavailable to us or is over-regulated in such a way as to make human freedoms impossible. Now, there are various rules that, of course, govern where we can be, but property rules are, within our society, hegemonic in governing generally access to valued resources. They don't just apply to land, they can apply to things like ideas or water. But of course, land is particularly consequential when it comes to human freedom and flourishing, if we follow Woolman and Waldron's line of thinking. Property rules, Waldron notes, quote, give us a way of determining in the case of each place who is allowed to be in that place and who is not, unquote. Private property rules are operative, quote, when an individual person may determine who is and who is not allowed to be in a certain place without answering to anyone else for that decision. I say who is allowed to be in my house, he or she or they say who is allowed to be in their restaurant. Now, this is, of course, obvious to us, right? This isn't, I don't imagine, breaking news for anyone in the room, but they're worth reflecting on. And in particular, the degree to which these ideas seem eternal, asocial, apolitical, unfixed, just simply the way things have always been. But of course, they're not predetermined. They're a social and political product. They're a product of struggle in all sorts of important ways. And they haven't always been with us. Property, which is simply a way of organizing people's access to a valued resource, in this case land, can of course be organized and has been organized in many diverse and multiple ways. It's, I think, very important to recognize that the idea of private property and the way people like Waldron and Wallman critique it are really very new. They were not conceptually available in English law and practice until the early modern era. And in particular, this idea of land as a parcel from which others should be excluded, that territorialization of property rights, is also something that departs very strikingly from earlier understandings of land and access to land. So of course, in a commoning system or a manorial system, access to land was governed by local customary right. And as legal historian Seep puts it, many persons other than the, quote, tenant in possession would work and live on a given parcel of land and derive a benefit from it. Many others would take some of its produce or simply make their way across it on the way to somewhere else. The image of one individual owner or even family excluding all others and taking all increase from a parcel of land would have been a vast oversimplification, unquote, in that pre-modern conception of English landholding. And the value of landholding rested not on its exclusivity. I mean, the value of land rested on the degree to which others had rights and access to it. Crucially, the primary relation of an individual to a parcel of land could be maintained without physically excluding others. Indeed, land had little value to the rightful holder if others were entirely excluded, as Seep puts it. Access to land was, of course, to some degree democratically negotiated through the manorial court, ensuring that local practice became formalized as customary right, which included not only the right of things like profit of prendre, the right of taking something, but also that the right of easement, the right to move on the land, the right of way, as I suppose we would understand it now. And of course, it was only by the 17th century and the emergence of capitalism and enclosure that property was reimagined violently by an emergent social class to be reconceived not as a relation, which of course it always is, but rather as a space, as an abstract space. It's my property, rather than understanding it in relational terms, from which others were to be excluded, creating the concept, of course, with which we are familiar, encapsulated in that concept of property as an imagined private castle. But a lawyer would tell you that even now, of course, property, private property, is much more than simply a castle. There's a long-standing strain of legal practice, even in modern capitalist notions of private property, that affirms people's right under certain conditions to access land held by others. So things like the public trust law or public accommodations law or the right to roam, all of these are clearly exceptions to that norm. And more generally, to imagine private property as simply a space of exclusion is kind of logically absurd. I mean, owners derive a benefit from their land in part by virtue of the ability that they have to include others, as well, of course, as to exclude others. A landlord has the right to make land available to renters, who have the right to invite guests onto their land, onto their home, without the landlord's permission. And a scholar called Kelly offers a useful thought experiment to alert us to the absurdity of thinking of private property as simply about exclusion. Imagine a world, Kelly says, in which you cannot include others in the use, possession, or enjoyment of your private property, and others cannot include you in their property. Such a world, Kelly says, quote, differs dramatically from the interrelated and inclusive world in which we live, work, and play. Inclusion is critical because human beings depend on each other, not only to survive, but to flourish. Our rights of way, of course, are crucial in carving out conditional forms of spatial of spatial access in this context. But of course, they are highly conditional, and they have to be fought for, given the hegemony of this private property logic, which assumes this notion of exclusion. And I was, in thinking about today's seminar, I was reminded of Nick Hayes' book, which I'm sure many of you have read. If you haven't, The Book of Trespass, then you absolutely should. And I should note that Nick Hayes has some rather some interesting comments on rights of way, and the degree to which, although they're important and need to be fought for, they're also highly constrained in terms of the claim making that people are actually articulating. So he talks, this is on page 90 in the Book of Trespass, about the way the process of designating rights of way, and he notes that while these definitive maps that legitimize and formalize rights of way, while these definitive maps enshrine a public right, they simultaneously legitimize the space that is off limits, the private right. Every pathway that is secured by law further strengthens the fence between us and the land either side of it. Our rights to the land, he points out, have become streamlined into thin strips of legitimacy, the freedom to toe the line. The real question, he asks, is why we allow ourselves to be fenced off in this way. Why do we obey the command of signs and the limits to our freedom silently scrawled across the land in lines of barbed wire? Where does this obedience come from? And this gets, of course, this isn't to gainsay the importance of the argument that rights of way are crucial and should be defended, but I think it alerts us to this larger question of why is the land not more generally available to us, particularly land that is held in very large land holdings. We're not talking about accessing domestic space, where we're talking about the right to roam, I suppose, or allemansrätten in the Swedish context, or common right, as was of course widely understood in historical contexts, which alerts us to the continued work, the violent, exclusive work that private property continues to do. And here I think trespass enters the room, which is why Nick's book about trespass is so important. But it's also important to also historicize trespass and understand where trespass comes from and how it is that perhaps it does have this almost mystical kind of effect upon our decisions as to where we do or do not go. Now, trespass, as I'm sure many of you know, traditionally was understood in law simply as a harm, a wrong done by one person against another. So murder, for example, was a form of trespass. Forgive us our trespasses as we forgive those who trespass against us is not a commentary on land access, it's a commentary on harm and the harms that individuals do to others. However, as property became understood in this more singular exclusive sense, as I mentioned before, this very ancient action of trespass was squished into this much more narrowly understood definition, whereby it served to defend landed property, including that recently enclosed, which is now reimagined in this more sharply territorialized terms. An English judge, Lord Camden, in 1765, our law holds the property of every man so sacred that no man can set his foot upon his neighbor's close without his leave. So that's that modern concept of trespass, and it's a very modern concept. And trespass, of course, is immensely powerful. It's an absolute veto in some senses. As one American lawyer puts it, a fellow called DePorter, it remains the legal prerogative of property owners to exclude all others from their land, regardless of the reason for exercising this veto right, whether the decision is based on spite, opportunism, or mere caprice. Now, trespass to land, if you actually unpack it, is really weird. I mean, it's a very strange concept. We're not talking about invasions into people's privacy. We're talking about this formal understanding where trespass occurs when a person steps on the, sets his foot upon his neighbour's close without his leave, to go back to Lord Camden. Trespass to land is actionable regardless of the extent of the incursion, without any necessary showing of injury or damage to the claimant. Trespass to land is quintessentially territorial. Merely to cross the boundary, even unintentionally, is potentially to commit a trespass. Two American scholars who are actually quite pro-trespass make the point that, quote, the midnight streaker who dashes unseen across the lawn of another and merely bends a few blades of grass in the process is guilty of the tort of trespass. And formally, trespass, because it's a harm is governed by tort law, as Merrill and Smith point out there. And tort denotes an injury upon the person, which is again striking. So trespass, which is somebody stepping on somebody's land, is an injury to the owner. The presumption there is that a person's land is an extension of their self. And as Nick Hayes puts it in his book, to step over the line into private property, to step beyond the right of way, for example, is in the eyes of the law not an act of digression, but of aggression, and makes the landowner the victim. So trespass thus takes us directly to questions of personhood and property, which I think are interesting, because it also then alerts us to the ways in which a property regime holds up certain forms of personhood while imagining others as less worthy of personhood, or even as a threat to personhood. If you read the rationales for enclosure in the 16th, 17th, 18th century, for example, they frequently reframed the commoner as now imagined as outside property, as a threat to property, as somebody who was not a property owner, or rather not as somebody who had a legitimate property interest in land, which of course a common property right would allow, but now somebody who's beating down the door, who's a threat to my property, and we must harden our property boundaries as a consequence. Justifications for, so 18th century Scottish improvers likened Scottish Highlanders to Africans or indigenous Americans. The violent dispossession of the Irish was rationalized by English assumptions of Irish paganism, and thus the barbarian status of the Irish, the less than human status of Irish people. It's clear that colonial dispossession in the land upon which I now sit, which denied the property personhood of indigenous people, weaponized trespass. So trespass was and continues to be an instrument which holds up and sustains colonial dispossession. And we can also then, of course, consider the racist weaponization of trespass in the uptake of so-called stand your ground laws in many American states that empower owners, mostly white, to use lethal force against trespassers, mostly black. But we also need, and this is I think crucial, to remember the long-standing, sustained resistance to such logics, whether it was by 16th century hedge breakers in Oxfordshire, 18th century women gleaners in England, early 20th century labor organizers in Flint, Michigan, mid-century anti-Jim Crow counter-sitters in Greensboro, North Carolina, and contemporary indigenous opponents to extractive pipeline proposals in British Columbia. Their precarious status is in many ways a function of this exclusionary logic of private property in which trespass plays such a fundamental role. But in various ways, they articulate a collective right or a common right to, if you will, not be excluded. So I'll pause there. Thank you very much.